Welcome back, everybody. Please be seated. Okay, ladies and gentlemen, please give your attention to the closing argument. On behalf of the defendant, Christopher Shane Burbank, and Mr. Wayne Fricke. Mr. Fricke.
Thank you, Your Honor. If I may please the court, Your Honor, counsel for the state, colleagues over here at the defense table, Officer Rankin, Collins, and of course, my client, Mr. Pertzer's client, Officer Burbank. I want to start by saying I really appreciate, as we all do, you folks paying attention and getting through what I would suggest possibly has been a grueling case for a lot of different reasons, but obviously an extremely important case. So I'm going to try to guide you, as the instructions say, with my view of the evidence in this case. As the court had indicated, you decide what the evidence is. I may misstate some things, very possible. It's not going to be intentional, but if I do misstate something, your notes control. If I misstate the law, which I don't think I will do, but if I do, the court's instructions control the law. I can try to interpret them and give you my best interpretation, but ultimately the court instructs you. If you have questions about it during the course of deliberations, they'll tell you what the court will tell you what to do. You ask the court. I'd like to start, when I prepared this PowerPoint, kind of start these things, and I'm not very good at PowerPoint, I'll tell you that right now. So this is, bear with me, but I think I got it down. But I had to add a slide here, and this has to go with you determining what the evidence is. Just shortly before the break, the state, through Ms. Eakes, put up her slides, which of course she's entitled to do. And one of the slides she put up there was a slide from what she says the testimony is from Kenneth White. And we know who Kenneth White is. He's in the house, in the residence, and he was called by the defense and gave testimony. And she put this slide up there, and I can't play her PowerPoint, that's why I'm doing this. And she had, as part of her argument, the question was, and I think he said that when the next arriving car, the third and fourth officer, of course, which would be Ford and Rankin, arrived, that Mr. Ellis was in fully restrained, correct? And his answer was yes. And he did indeed give that response to that question at one point in time. But that question and that answer was taken out of context, and I believe that's kind of been the essence of the state's investigation in this case, as well as the prosecution. Because she has the same testimony, that's trial testimony. She has the same transcript that I have, that all the other attorneys have. When we followed up, I'll turn these on. When we followed up with Mr. White, Mr. Pertzer specifically, Mr. White, you said that you saw him get restrained. You said after the third or fourth officer, are you talking third or fourth officer, or the third and fourth car that arrives at the scene? And the answer was each car after that would have been almost individual police officers getting out of it. So how many cars at that time that you saw Mr. Ellis was restrained? The first point in time, how many police cars were present? 3 or 4. 3 or 4 cars, yes. That's why context is important. Because we know the first car, we have 2 officers, we have Burbank and Collins. We have the second car, we have Rankin and Ford. There's 4. If you got 2 more cars, whether there's 1 or 2, you're getting up to 6 or 8 officers, and of course we know officers arrive at various points in time, increasing the numbers as they go along. So this is what I will get into later on when I talk more about the evidence, but it is that context that's important when people are presenting evidence to you, because if they take it out of context and they don't give you the whole story, then you get misled. And it's one thing to do it negligently, it's quite another to do it intentionally. So before I begin, I think it's important, and I think it's important for everybody to recognize that Manny Ellis's life was no less important than any other life. His loss of life has had a tremendous impact on his family and his friends. Just like if you and I lost a loved one, it would have a tremendous impact on all of us, individually and perhaps collectively for your families. And for the families and friends, they feel they need to have someone pay for what they believe is a crime. And we kind of expect that from families and friends because they're emotional and their decisions and their opinions are based on love and emotion. It is not guided, nor can it be, by the law and the evidence. Now, I've never met Mr. Ellis. I have no reason to believe that he was anything other than a good person to his family and friends. No reason to disbelieve that he was a talented drummer, as was testified to, or he enjoyed going to church, in fact, went to church that night, or enjoyed watching his nieces and nephews. And his family, of course, they remember him that way, as they should remember him that way. Officers Burbank and Collins, likewise, had no knowledge of Mr. Ellis. Just like Mr. Ellis, all the officers charged here also have families and friends who love them and are concerned about them and hope that they'll come home safely every night, especially as police officers. Now, you can have empathy for Mr. Ellis and his family, and you can have empathy for the officers here, Rankin, Collins, and Burbank, and there's nothing wrong with that. But what you can't do is let sympathy, prejudice, as the court instructed you, or personal preference play any part in your deliberations. And that's what, again, the court instructed you to do. And it's also one reason why we have juries in jury trials, because you are in a position to apply the evidence in the law independent of any emotion aspects of this case, as you should, as you swore to do. Now, the prosecution alluded to this, and I agree. Like a lot of us, Mr. Ellis had his faults, no matter how he would have been a good person outside of those faults. And his faults specifically, and mostly, were his addiction to methamphetamine. And when he was high on meth, it affected him in ways that caused him to be violent, unpredictable, and paranoid. And that's what one would expect from regular meth, as testified to you by the toxicologist Asa Lewis, as well as some other medical experts in this case. But as Cedric Armstrong 2 months ago described, there was bad meth going around the community at that time. And that was in the late fall of 2019, in the early winter, spring of 2020. I don't know what the difference between the two is, but Armstrong stated it was having adverse impacts on individuals that were making them even more paranoid, unpredictable, and violent. This is the state's witness. This is the person who brought Manny Ellis into his house and attended church with him earlier that evening. And for whatever reason, Mr. Ellis, in violation of his curfew, he went to the 7-Eleven, apparently not unusual. And he went with a person by the name of Wendell Emerson that none of us know anything about, other than they went out together and they lived in the house. Both of them disappeared, and as you know, Mr. Ellis passed away. What we do know, at some time, whether it was earlier that evening or on the way to the 7-Eleven or the way after going to the 7-Eleven, Mr. Ellis ends up with a large dosage of methamphetamine in his system, equivalent to a fatal level. And we also know, as Mr. Armstrong testified, there was a drug house somewhere in the vicinity of 96 and Ainsworth. And it was the Manny Ellis who was high on meth, the paranoid, violent, and unpredictable Manny Ellis that officers Burbank and Collins encountered on March 3rd, 2020. It was after he put methamphetamine into his system, similarly to what he did in September 21st, 2015, and September 24th, 2019. And you saw the video of the 2019 incident, and you saw through that video how he can act when he is under, I would suggest, a concern that he was going to be facing some type of legal ramifications if he succumbed to being arrested by the police. In that instance, in 2019, of course, he was tased, I believe it was 2 times. And in that situation, one of the arresting officers actually had his gun pulled, ready to fire. He was so concerned about what was going to happen. Obviously, as you know, Officers Collins and Burbank did not have their guns pulled. They were trying to defuse the situation in the beginning, and it strung out of control. So this is a situation where he created his own death, and that happens, obviously. And certainly it's not a situation where Burbank and Collins desired to harm him, and nor Officer Rankin, Ford, or the other officers who came up afterwards. It was his behavior that forced the officers to use force against him, because he, again, unbeknownst to them, created a situation where they had to act. And Jack Ryan talked about that in his law review article. Cops are faced with situations where they are forced into using force against uncooperative suspects. When Mr. Ellis, after using meth, forced this situation, I would suggest to you the evidence shows that the clock started ticking and all the abuse that he did to his body came to a head, something the officers were not and could not be aware of at this time. Now, in his closing, Ms. Eakes indicates, well, he could have come home if this didn't happen and be alive today. He'd be safe and he'd be at home. And I think that belies the evidence. Dr. Mitchell testified the only reason he attributed this to hypoxia as part of the struggle is because it happened. He acknowledges, as do all the other doctors acknowledge, that he had a fatal dose of meth in his system. He acknowledges, as all the other doctors acknowledge, that he was in a situation where he had a bad heart. So it's surprising that the state suggests, at least from my perspective, that they tell you because he didn't die, and actually Dr. Mitchell mentioned this, that he didn't die in September of 2019 under similar situations, and therefore that's why I say he died under these situations here related to the struggle. I have to say, look, anyone who has a heart issue, whether it's me, you, I hope none of you do, for someone to suggest because you didn't die at 5 o'clock today in the morning, that means you're not going to die at 5 o'clock this afternoon when you have a heart condition or a fatal dose of meth in your system. It's nonsense. You are a walking time bomb, and basically you are waiting to die if you don't get help. Notwithstanding that, the state's here, they said, we want to compound this tragedy. We want you to find these officers guilty of either murder or manslaughter in this case. And I'm suggesting right now it's not based on the evidence, but it's based on something else. Now, this is your instruction number 4. You all have it. Obviously, judge read it to you. You're going to read it when you're in the deliberations there. But you know the essence of it. And we're all guided by that first paragraph, that we're presumed innocent. We're all entitled to this. You folks are presumed innocent. Everyone in this courtroom is presumed innocent. It's the essence of our country. These officers, as they sit here this very moment, they're presumed innocent, as they should be. And I'm asking you, once you start deliberating the evidence and the facts in this case, that you maintain that presumption of innocence, and when you come to a conclusion, which of course I think should be not guilty for all of them, that you let them leave this courtroom just like you're going to leave this courtroom with the presumption of innocence remaining. Because that's what this case should boil down to based on the evidence of the law. Now, you represent the people of the state. It's you to decide where the state has proven its case. And I would suggest to you, unlike the people, and you heard from Officer Ford, who attacked him and called him a murderer on social media, forced him to move to a different location and remove his social media accounts, your decision is based on evidence in the law. And what everyone in this courtroom should agree on is that it's not based on Dr. Clark's statement that there, quote, there is some value to the homicide classification toward reducing the public perception that a cover-up is being perpetrated by the Death Investigative Agency. This should not be a political decision. It would be horrible if someone reached that decision one way or another based on politics or otherwise. And that's a statement from a man, a professional, a medical doctor, who on no less than 2 occasions prior to this incident, under similar circumstances, found that the cause of death was not the result of hypoxia, but rather a drug overdose. And a drug overdose that was based on levels of methamphetamine that were significantly less than we have in this case. So before I get into our evidence that we presented, and we did present evidence here, as you know, again, there's no burden on us to provide that evidence. But the first issue I want to address is causation and proximate cause as it relates to the cause of death. And the reason I'm starting there, and I'm not going to get into a lot of detail of it, but the reason I'm starting there is because if you were to come to the conclusion, under all the other elements of these charges, whether it be murder or manslaughter, the final element, other than it occurring in the state of Washington, and I'll concede that the incidents here occurred in the state of Washington. That's the only concession you're going to get from me. But I start there because even if you found the other elements occurred, you still are required to find these officers not guilty if the state hasn't proved its case beyond a reasonable doubt as to the causation. And I know the other counsel here, Mr. Osser and Mr. Conrad, they're going to follow up here, are probably going to go in this a little more detail than I am going to go into. So I'm not going to belabor this point. But what I want to tell you in the context of analyzing the issue here, you're going to be looking at these doctors' testimony. Dr. Mitchell, Dr. Dan, Dr. Veal, and Dr. Clark. And instruction number 24, which you have, it talks about the elements of murder and manslaughter, but it talks about proximate cause. And to constitute murder and or manslaughter, there must be a causal connection between the criminal conduct of a defendant and the death of a human being, such that the defendant's act or omission was a proximate cause of the resulting death. The term proximate cause means a cause which in direct sequence, unbroken by any new independent cause, produces a death and without which the death would not have happened. And then there's the last paragraph on superseding cause. So I'm suggesting to you there's 2 issues related to this proximate cause. The first is the utter lack of agreement as to the cause of death from the testimony of the state's expert. Remember, they have to prove causation. The only thing they can really agree upon is that this is a complex case, and reasonable minds can differ as to the cause of death. And the second issue is when Mr. Ellis was in a state of no return, or when he was in a state of no return. From all of the testimony, it's safe to say that actions and inactions after Officer Burbank's involvement intervened to cause the death of Mr. Ellis. But under either scenario, Mr. Burbank's actions were not the proximate cause of the death. So here we have Dr. Mitchell. And obviously he testified for a long time, and I think a couple days on the stand, and again, people are going to go into more detail. But this is the essence of his ultimate conclusions, his opinion in this case. Reasonable minds can differ as to the cause of death. And it's too speculative to determine how much time would have made a difference for Mr. Ellis to survive. Dr. Dan, reasonable minds can differ as to cause of death. A super complex case, you can only speculate as to when Mr. Ellis would no longer be able to recover. Dr. Curtis Veal, Mr. Ellis was not hypoxic during the initial struggle with Collins and Burbank. He became somewhat hypoxic when the hobble was placed on him, but he still had the ability to recover once he was placed in the recovery position the first time. And like the others, the case is super complex. So that's, in a nutshell, the state's case as to proximate cause. It's based on speculation. If the doctors can't testify definitively beyond a scientific opinion as to the cause of death, The state can't get up here and argue for you to say, you should find we proved our case beyond a reasonable doubt based on these differing opinions and all the conflicts that are going on. That goes to, again, the causation as it relates to the death. And again, when you go to that reasonable doubt instruction, as it says there, it can't be based on lack of evidence or affirmative evidence that's based on speculation. And that's all we have here. Now, this case goes much, much beyond that. When I said I'd start out, if you found out that the officers acted inappropriately, you go to causation, you still find them not guilty. I don't think they operated inappropriately out in the field here. Obviously, you have the elements in the two convict instructions of murder and manslaughter. As I mentioned, this happened in Washington. And then you get into, especially the murder, no one say that Mr. Ellis was intentionally killed, and they're relying on the underlying felonies of second-degree assault, third-degree assault, and unlawful imprisonment. So what's the premise of the state's case? And I'm suggesting to you, and I think it was argued here this morning, the premise is this. Since they're saying they didn't intend to kill Mr. Ellis, which I don't disagree with, that Officers Burbank and Collins, for no reason, began assaulting Mr. Ellis on the night of March 3rd, 2020. For no reason at all. That these two men, who were admired and trusted by all the other officers in the department, and certainly Ford and Rankin, who were awarded the Medal of Merit for de-escalating a dangerous situation involving an individual with a butcher knife, suddenly out of the blue decided to attack an innocent person in the community. That's their case as it relates to the murder charge. If there is no evidence, there's no background to suggest that's even a plausible explanation. And this gets into the evidence they've ignored and the evidence that they've presented and spun, in my opinion. And I would suggest to you the state hasn't proven its case in a number of different ways. They haven't proved its case when they rely upon a witness who's indicated that she's going to lie on the stand. Now, they gave it an excuse. They talk about excuses and a justification, but I guess Ms. McDowell gets a free pass. But we know that she said in her face, I think it was the social media posting, that she's going to lie on the stand. When they rely on a scattershot approach, saying, well, you can find them guilty by either using assault in the second degree, assault in the third degree, maybe unlawful imprisonment. We don't know which. We don't care. Just do it. That's what they're arguing here. That's not meeting its case beyond a reasonable doubt. When it attempts to restrict the information that you hear by deciding what is relevant, which is what Mr. Fredericks had testified to early on. He says, well, I just didn't think it was relevant for you guys to know that. When they make that decision, I mean, those are decisions for you to determine what's relevant and what's not. So when they do that, they're keeping information from you to make a just decision. And the state hasn't met its burden, I would suggest, when it ignores witnesses who have intimate details as to what happened at the scene. And nor has it, again, met its burden when it asks you to speculate as to what happened. So who have they brought? Who have they not called to testify in this case that we had to follow up and call to testify? And I think the one person who sticks out is Messiah Ford. And for the life of me, I cannot figure out why you would not call Messiah Ford. Out of all the witnesses who testified in the state's case, arguably he would have some of the most relevant information as to what happened to Mr. Ellis when he was finally secured at the scene. He was hands-on. They know He has information about Burbank specifically. Burbank trained him, thinks the world of him, holds him in a very high regard. Says he treats, referring to Burbank, suspects with dignity. Based on his knowledge, when they finally heard his voice on the 911 call through dispatch, he said he could tell he was exhausted when he was finally able to give out their location. That's pertinent information I would think all of us would want to know if we were in the same situation as these officers over here sitting at this table. If it was you, your children, a friend, wouldn't you want that information for a jury to decide? But they don't give it to you. They try to keep it away from you. Shad Hayes, eyewitness. He talks about what he thought was these aren't his words, but I would suggest it was I would characterize it as a monumental struggle, and these guys were struggling to get this situation under control. We're going to talk about the instructions, but all that information is pertinent to how the officers acted. And the same thing is with Kenneth White. Why not call him? Those two individuals have extremely relevant information to give. And again, Frederick said, I just decided to keep out relevant information. And what's relevant about all this stuff as we go along here is we all know, and there's no dispute, that this video that the state relies upon basically in total does not include all of what happened out there at the scene. We know that for a fact. So when you look at the evidence that they went through, and the evidence specifically the testimony of these civilian witnesses, which it appears to me they rely basically almost exclusively on McDowell, perhaps Lowry a little bit, somewhat of Cowden, and they basically ignore until the very end White, Ariana White. Ariana White actually conflicts with what McDowell has to say. So when you look at this, I take you to instruction number 26, and I forgot to mention Dr. Clark, but again, he had three different possibilities of the cause of death. But one of the things he also indicated when they're, and it really goes against their case, because this is a hypoxia due to restraint that they're arguing, he said there's no studies that support that. There's none that supports that theory. And so they rely on the video and they rely on McDowell. Well, what does the video show? It shows, after a period of time, a struggle with Collins, with Ellis on the ground. Now, they want to say Fredericks, I guess he's some kind of god that you have to accept his testimony. The instructions say otherwise. And I think he's either lying or doesn't want to acknowledge that that video shows, at a minimum, Ellis pushing with his foot, if not kicking him away, in that video where he goes behind the car. It doesn't show a patrol car driving up. It doesn't show McDowell's vehicle driving up. They're just there. They just appear out of nowhere. And we know it doesn't show the beginning of the struggle. It doesn't show Ellis coming to the window of the patrol vehicle. We know he came to the window of the patrol vehicle. There's no other explanation for that. So this is kind of the beginning of the situation right after you get this, my client's statement, Mr. Burbank, you get the testimony from Officer Collins, when they notice him in the middle of the intersection. And they notice him there, and that's kind of the beginning of the incident. Now, if you go to instruction number 26 that the court gave you, and this kind of sets out the duties of the police officers. And one of the duties is a peace officer not only has a specific duty to enforce the law, but is also charged with the general duty and power to maintain the peace and quiet of the city. That's their duty, and there's a reason for that, because if they don't enforce the law, that opens up the cities for liability, potentially, for them not doing their job. So they have every right and, again, obligation to at least check in to see what Mr. Ellis is all about when they see him out in this street, whatever he's doing. Now, they can mischaracterize it and say, well, Collins said, he may have been doing a carjacking. Well, you go through those questions, and you heard his testimony, and you had his statement. They ask what the possibilities are, and he just throws out possibilities. And he doesn't say one thing or another, something happened, but it does put up there, he's going to do his job and find out what is going on at this time. And that's the beginning of this. And then it's after that, you heard their testimony, you heard Collins' testimony, you heard my client's statement about what happened afterwards. Sarah McDowell, of course, she didn't say anything about that. Now, it's interesting to me that Sarah McDowell, and Lowry for that matter, they both say they saw nothing other than Mr. Ellis, of course, who they don't know at that time, going to the car. And he did absolutely nothing. And they just jumped on him. And McDowell at one point, I believe she says they just went to the side of the car by the door, and that's where she has them located. It's interesting when they say they saw the very beginning of this thing, then why in that video with the audio that we just heard again here this morning, Sarah's saying, just arrest him, just arrest him. If there was nothing to arrest him for, why is she saying, just arrest him, just arrest him? Keon Lowry, right behind her, says, hey, y'all in the wrong right now. And that's when they're there. They know something happened before this video kicked in. We know that their phones are not accessible. Now, I don't know where those phones, I know where the phones went. We have the one phone of McDowell, but you can't access it. You can't access it because someone put in 10 different passwords knowing at 10 you're done and you can't get into it. So yes, the physical phone is here, but the information contained in that phone is not available. And this phone has been sent to the best of the best to try to get the information, and you cannot get it. Is this just coincidence? Lowry, same thing. We can't access his phone. That phone doesn't exist anymore. He doesn't remember the friend he gave it to. But what we do know, when he was driving down the road where he says he saw what happened, it's just physically is not possible. None of that, what he testified to, could happen. There's no way when he's driving down the road he could see Mr. Ellis go to the side of the car. What he does indicate, and this starts getting inconsistent with McDowell, is that they were in the middle of the road and Ellis was trying to get away. He was running away from him in the middle of the street. McDowell says it appeared to be an assault. She says she never saw Ellis get off the ground. Well, we know he got off the ground. We'll talk about Ms. White's testimony here in a moment. She says the two officers got up at the same time and jumped him. That he was always by the police car. We know through Wells, who did the measurements, he wasn't always by the police car. At one point, I think he has him 26 feet away in front of the vehicle. The other thing he had, that the struggle going on, that there was a movement of, I believe he said 6 to 10 feet, but again, you guys taking notes, you decide what he testified to. But it's pretty clear that there was a lot of movement going on. And they say Ellis didn't do anything. Never saw anything in Ellis's hands. We know he had something in his hands. And again, Cowden, driving up Ainsworth, where he's at, there's no way, again, that he can see what was going on. But what he did say, which is kind of consistent with their verbal statements on this, this phone tape, thought the officer was trying to arrest and restrain Ellis at the front of the patrol vehicle. He says the officers got out this patrol vehicle at the same time. It's interesting that he and Cowden have that, he and McDowell have that same statement in there, as well as other statements. in June of that year. At the same time, they're meeting with Attorney Bible. Now, I don't know Attorney Bible. I don't know what happened. But it's pretty coincidental that things kind of dovetail after that point in time. The state was talking about how Ellis ended up on the ground. Cowden says, I don't know how he ended up on the ground. There was a struggle, I think he called it a melee going on. He does remember being tased while avoiding being handcuffed. And Ellis tried to get away. Now here's the testimony snippets. These aren't verbatim by any means, of Ms. White. And when you look at her statement is very consistent with what Officer Burbank said in his statement. And first of all, if you remember, she hears two male voices yelling. When she looks out the window, and remember, this is before she hears McDowell's voice. So she's hearing and seeing this before McDowell's even at the scene. And what she sees is both officers, I should say, she sees one officer and Ellis were standing. Now she's assuming the officer was the driver of the vehicle, which obviously is Officer Collins. We now know that's not Officer Collins, it's Officer Burbank. And they were standing. And she says Ellis was struggling to get away. It appeared to be an attempted arrest. She couldn't see the second officer if he was going to be on the ground, or if he was on the ground, which I believe he was. I think the evidence supports that. And she, like Cowden, doesn't know how he ended up on the ground. Will he trip? Whether he fell, or if he was pulled on the ground, which is consistent with Officer Burbank's statement. And she, like Wells, verifies that officers and Ellis' position moved as the struggle continued. And she consistently throughout this time, through her observations, thought it was a person attempting to evade arrest. She likewise doesn't see anything in Ellis's hands. And again, we know that's the case. What I wanted to show you, I'm going to come back here. So that's her testimony. She has officers, or again, Officer Burbank, again, she didn't know who it was, along with Mr. Ellis, in the front of the vehicle by the driver's side light, the headlight. McDowell never has him over there. Lowry never has Ellis over there, and she has him standing. So we know Ellis was standing at one particular point in time that was witnessed by one of the civilian witnesses that's not discussed by the state. And that's significant, because we know that tape doesn't show everything. We do know the tape does show ultimately a struggle going on. But that struggle, when it occurred and how it occurred, is consistent with Officer Burbank's statement when he gave it a couple days after the incident. And so when you look at what their duties are, once he began resisting arrest, according to instruction number 28, the officers had every means within their power to make an arrest. And when he started fighting that arrest, he was resisting arrest. That's the beginning after they're doing their duties. They're trying to inquire as to what's going on. They're trying to find out what's going on with Mr. Ellis. They don't know what he's all about. They don't know what his situation is. But what they do know, he's in some type of situation that they have to inquire of. And it's in the context of this particular point in time when you start seeing the force, which is not the beginning of the force. That's when you start judging the reasonableness of their actions and the force that they use. Now, all of these instructions that follow, all of them talk about it being illegal if, instruction number 9, which is it's not murder or manslaughter if the killing is excusable. Instruction number 12, it's not an assault if the force used was lawful. Instruction number 21, It's not unlawful imprisonment if done with legal authority. Instruction number 31, these cover all the to convict instructions. Necessary force, there's no reasonably alternative existed, and amount used appeared reasonable at the time. Instruction number 32, it's a defense to murder and manslaughter. The force used was lawful. It's the state's burden to prove that it was not. It is lawful when necessarily used by an officer in performance of his duties. And instruction number 33, excusable. It is the state's burden to show that what the force used was not excusable. Now, it's important to look at this when you talk about the use of force in this situation. And this goes to the expert testimony, which is consistent with these instructions, for a little bit anyway. You heard you heard the experts, Jack Ryan and Chris Nielsen. In most parts, they agree on the law, with the exception of Jack Ryan says it's an objective standard. And he's wrong. It's a totally subjective standard. Not totally. It's a subjective standard at the time it's going on. You don't use 20/20 hindsight, and you've got to put yourself in the perspective of the arresting officer at the moment it's going on, and that's a subjective standard. And he's wrong on the law. And you'll, as you notice, perhaps, a lot of what they rely upon is the testimony of Chris Nielsen. And well, Chris Nielsen, he testified here, and in my opinion, he was very credible. And I think the state thinks he's very credible. Because if they don't, it's only one of two things. They're either shopping for people, meaning Jack Ryan, who will say what they want him to say, or they're just not competent in the sense of protecting the public and the resources of the state of Washington. If they're hiring Chris Nielsen, presumably they're hiring because they think he's a very credible individual. They didn't hire him here, and there's no explanation for it. Jack Ryan, on the other hand, he's part of an email exchange where their names were he, Mitchell, and Dr. Dan, I guess, go around the country, and they put themselves out there, and they'll say pretty much what they want to say, which I think is what happened in this case. And the important part of this thing is on the use of force, and this came from the case, you heard us talking about it, is police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. And that's what happened here. It's like Nielsen said, this isn't about proportionality, it's about quantum of force, and it totally makes sense. You're not going to meet force with the same amount of force. You've got to get the situation under control. And to get the situation under control, you've got to more than match what this person is doing to you. Now, they can say he wasn't resisting arrest, but you see the videos. I encourage you to watch the videos, and I know you're going to see him again here. But he clearly is resisting arrest. And he's resisting arrest every moment when those videos are playing, which, again, are minimal because there's, I think, a minute or so total. There's not a lot there. But he's struggling the whole time. And they have an obligation. And they have an obligation to get him under control. And that's what they're trying to do. And I think it's nonsense to suggest he's not resisting arrest. So it's not an unlawful imprisonment. They have the authority to do what they're doing. He's assaulted them. He has started the assault minimally at the time he went to the window and hit that window. And we have proof there was contact with that window. There can be no realistic dispute as to that in this case. And so, as this went along, they were forced to escalate what they did. Now, they show these photos of Burbank and Collins, say, well, look, there's no injuries on them. They have a couple of scrapes, big deal. Well, you don't have to be shot before you shoot, if it were a situation involving a gun. You don't have to be injured before you seek to get the guy under control. It may be that you will be, but this isn't about comparing injuries and saying, well, they have little injuries, so they have no reason to use force against this guy. Clearly, they did. The videos show that. And they were trying to get his hands behind his back, as repeated many, many times, during the course of that engagement. And they failed, and they failed, and they failed. And it was only until they failed throughout this altercation that Mr. Burbank, realizing that wasn't going to work, then goes to his taser. Now, he gave a statement. He thought he did the tase 4 or 5 times. And anyone who's been in a fight, no one has to raise their hands, but if you've been in combat, in a situation, you don't remember what's going on. You're acting under the circumstances. You're reacting to what's going on. You're making those split-second decisions that these officers are trained to hopefully do correctly, but certainly not to look back at them and say, oh, man, you should have done this differently. As Nielsen said, it's not about doing it differently. There may be other alternatives, but you got to put yourselves in their shoes and make the decision that they're making at the time. So long as it's reasonable, then there's nothing wrong with that decision. Ford says they did nothing wrong. Nielsen says they did nothing wrong. And Jack Ryan, even though I think you should pretty much ignore most of his testimony because he doesn't know the law, he acknowledges if these guys were assaulted, as they explained, they didn't do anything wrong at that time. He says that. And then what he says differently, though, here in front of you, is that, well, maybe they did some things they shouldn't have, and they use this in their closing argument here. They shouldn't have used the elbows. They shouldn't have used the feet. They shouldn't have used all this. When I questioned him, this was a testimony. I said, well, I used the prior interview. I asked him, what are you saying happened here? I'm saying that certainly at the end, the restraint process, the pressure on the back, absolutely, and left in prone position, absolutely. And so when I asked him, well, what do you mean by the end? He says, so when the officers get him finally restrained in a hog tie, which is not a hog tie, by the way, then the immediate action should have been to get him in a recovery position, and then that all the officers involved in that hog tie and restraint process had that responsibility. That's what he said when we're doing the interview, so he changed his testimony here. So there's at least an acknowledgement that if you accept our client's testimony, which I think you ought to, because nothing else makes sense, that nothing up until he's in that restraint position was unlawful use of force. They told him to put his hands behind his back. They gave every indication that they were going to arrest him, and he continued to resist. The law is use all necessary means to effect the arrest, and that's what they were trying to do. That's what they had to do. That's in their policy manual. It's also in the policy manual that they could use tactics outside their training. And it's only and that's the last paragraph there, when situations are reasonably stabilized, application of force must proportionally de-escalate or cease in accordance with subject's actions when control is gained or threat is removed. That's at the very end of this thing. That's when they could start thinking about Mr. Ellis or any other suspect they might have in custody, is when he's under control. And we know Mr. Ellis, at least in a prior situation from 2015, he used a ruse. He used a ruse when he told them, give him 2 sets or lengthen the handcuffs, and then he used it to try to get whatever drugs he had in his pocket out of the pocket. The officers here, Burbank and Collins, they said they didn't hear him say, I can't breathe. But again, if you've been in an altercation where it's hand-to-hand combat, which is how I would describe it, you're not hearing everything. Aladorn said the same thing. He talked about the noon cocktail thing. You might not hear what's going on because you're so focused, in this case, in defending yourself. And all the instructions here allow for that to happen here. So when you look at these instructions, we'll run through a couple. Necessary means, instruction 31, necessary means that under the circumstances as it reasonably appeared to the actor at the time, and that's a subjective determination. They went through the process. They went through the quantum of force as they were trained. as the experts trained in this state, and the amount of force being reasonable to affect the lawful purpose being the arrest. Under lawful imprisonment, which the state is relying upon for a conviction, the use of force upon or towards a person of another is lawful when necessarily used by a peace officer in the performance of his legal duty. Again, we know it was necessary in this particular case, and again, they followed the law. And it's really important to remember, amongst other things, it's a defense to a charge of murder or manslaughter that the homicide was excusable as defined in this instruction, and is excusable when committed by accident or misfortune in doing any lawful act by lawful means, without criminal negligence or without any lawful intent. The testimony, the manuals, the instructions all indicate that what they were trying to do here was with lawful means, and the state hasn't shown otherwise. And again, it's not for us to show that it was lawful, it's for them to show that it was unlawful. And they haven't done this in this case. You know, sometimes things happen. They're under the stress of the event. You look at manslaughter in the first degree when it talks about recklessness. A person is reckless or acts recklessly when he or she knows of and disregards the substantial risk that death may occur. Well, when you're looking at that, it really assumes some type of thought process. They're in the course of the struggle. They're not thinking about, geez, A, B, C, D. That's what we think about in courtrooms. They're thinking about getting this guy under control. They don't know at that point that he's under the influence of methamphetamine. They don't know of his medical situation. All they know is they're being attacked by a guy out in the streets in a dangerous part of town, and they're acting accordingly. There's no evidence in this case that they were actively disregarding any risk, let alone a substantial risk that death may occur. In fact, they felt otherwise. And they tried to get them under control. They were only able to get them under control just very shortly between Rankin and Ford arriving and Lim arriving shortly afterwards. And right when Lim arrived, they make the call. Lim took control of the scene. We talked about intervening cause earlier. When he took control and everything happened after that, those are intervening causes. So based on all of that, you should find them not guilty of the charges. So I'm going to Officer Burbank's statement, and I want to, the state is saying none of what he says makes any sense. In his statement, he indicates that Ellis had a jug of water in his hand. Exhibit 0168, there's a photo of a jug of water. The state shows you at least an exhibit as to a jug of water. Burbank says at that moment when he hit the window, or just shortly before, he dropped something. He didn't know what it was. We know in Exhibit 0159, there's a photo of a box of donuts. That the state now comes there with an exhibit and says, here's a box of donuts. He says he hit the window. We have the photos of the smudges. He says after Collins got out, and you have to remember, now Burbank's not going to see everything Collins sees because, number one, first, it doesn't make any sense. Look, if people are doing the exact type of testimony, it probably means they got together and were saying the same things and coming up with a plan, much like Cowden and McDowell did. But what he does say, he went back to the car and he wanted to secure the car. When he gets out there back, he's not seeing Collins at that point in time. And of course, nor is White, because I believe that's the point in time when they go to the front of the car, when Burbank is trying to get distance between him and Ellis, and that's when White sees him at the front of the car, and then sees them go down but doesn't know how they go down. And that's through the White testimony, and Cowden too. He says he then had to gather himself, and that's when he sees Colin on top of Ellis on the back, and that's when you're starting to get in the video, and of course the taser application. All of his statements are supported by objective evidence. There's a jug of water. We all know that. A box of donuts. The state says, no evidence that box is open. Well, there's no evidence it wasn't open because the box is upside down. We don't know how Ellis handled those donuts. We also know in some of the photos that I'm sure are going to be shown to you sometime, and certainly you'll have them in front of you, that there was white powder on, potentially white powder, but we don't know what it is because no one did the testing. But it was on Mr. Ellis's, I believe it's his left hand, and he's left-handed. We have the streaks. And again, we have the position that Ms. White testified to. These are the types of things that you look at in assessing one's testimony. There's nothing to say, there's no evidence that's been provided that these officers, Mr. Burbank, that I represent, committed any criminal charge in this case. He did what he was trained to do, as testified to by Mr. Nielsen. He did what the facts required him to do, which is through basically all the witness testimony with the exception of McDowell. And based on that, you should find these defendants or these officers not guilty of the charges. I invite you to look at the medical evidence, again, in more detail than I've gone over it. I invite you to look at those videos in detail, and you'll see in the videos, basically, when you look in the generalities, that those videos support what Burbank says. And White's testimony is almost spot on, and she misses some things. She doesn't remember two officers, but the way it's described by Burbank, almost spot on. So I'd like to end with this. You know, the situation here is tragic, again. It's certainly tragic for the Ellis family. And, you know, that's sad. But this is a hindsight case. It's an unjust case if there's ever been an unjust case. Sometimes things happen, and you have the Tacoma, you heard about the policy manuals, and you have the instruction here. You know, sometimes a person just dies under unfortunate circumstances. And I think that's the case here. No one wanted him to die. No one sought to have him die. Even the officers who took control of the scene after Burbank wasn't involved, they didn't want him to die. But ultimately he died. And that's sad. But we don't compound that tragedy by convicting innocent people of these charges. So I don't get another opportunity to speak to you. The state will. And the other counsel here will get an opportunity to speak to you, and they won't get a second opportunity to speak to you. But I would ask you, while you're listening to the state in particular, when they have their rebuttal argument, that you question them heavily in this case. Why are they hiding evidence? Why were they not getting evidence? Why are they misinterpreting and taking out of context evidence? Context is everything in this case. All those instructions that talk about excuse and lawful conduct, that's all about context and subjective determinations. And so I thank you for your time. And again, I would ask you to find Officer Burbank not guilty of these charges. Thank you.
Gentlemen, we're at our normal afternoon break, so we will take our recess for 15 minutes. Please do not discuss the case among yourselves with anyone else. And do not permit anyone to discuss the case with you or in your presence, and of course avoid any reports to the newspaper or media subject to this trip.
lasagna.
It's like,
I was like, are you And he kept calling, he called her Aria.
oh no. There, those are the nonsense. All the names of the witnesses were wrong. He's like your best friend's dad. I feel like he's so likable.
This is why.
Okay, welcome back, everybody. Please be seated. Okay, ladies and gentlemen, please give your attention now to the closing argument of Mr. Jared Osser on behalf of the defendant Matthew Joseph Collins. Mr. Osser.
Don't let the facts get in the way of a good story. That's what my mom used to say when I was that big, when I tried to pull a fast one on her or manipulate something in front of her. I know what you're thinking. I'm not much bigger than that now, but I assure you it's when I was a kid. But Mama Osser's not the person who coined that phrase. That phrase actually comes from Mark Twain. Mark Twain said, "Don't let the truth get in the way of a good story." And the state in this case is not letting the facts or the truth get in the way of the story they're trying to sell to you. And that's just wrong. Now, don't get me wrong. There's no question that Mr. Ellis was a good brother to Monet, a good son to Marcia, a good uncle, a good father figure to the children that he was looking over when he was sober. We know when he was high on meth, he was a different person. We know that Mr. Ellis had mental health issues. He was bipolar, he was schizoaffective. We know he had long-standing health issues. And we know that those issues were exacerbated by his methamphetamine use. Those are facts. And we know that when he used meth, it affected the way he dealt with law enforcement. We know that because on 3 separate occasions, we know how he reacted when he was high on meth and dealing with the police. And ultimately led to his tragic death on March 3rd of 2020. But the tragedy of his death doesn't make Officer Collins' conduct criminal. And that's a distinction. And don't let Bob Ferguson, the AG's office, or their army of attorneys, or staff, or their unending tax dollars they've thrown at this case through expert witnesses to try to get you to see what they want, hear what they want, or determine what happened as they want. Because you can tell with your own eyes, ears, and common sense what actually happened. Because I think, as Mr. Fricky said, the only thing greater than the loss of Mr. Ellis's life would be to find Officer Collins or any of these other officers guilty based on anything except what the facts were proven in this case and the law that Judge Shushkoff gave you. Now, the state has to prove that the conduct by Officer Collins was criminal. Step 1, was it criminal? Did Officer Collins have a lawful authority to either arrest or detain Mr. Ellis? And third, is there any evidence whatsoever that any act of Officer Collins caused the death of Mr. Ellis? And so Ms. Eakes did exactly what I thought she was going to do in her closing remarks. Her first slide, quite frankly, was 3 civilian witnesses. Their entire case is based on those 3 civilian witnesses. And I'm going to submit to you those 3 civilian witnesses are not credible at all. Quite frankly, Ms. Eakes says you can tell how afraid they were on Ms. McDowell's video, Exhibit 20. Well, if she was so afraid and so disturbed about what happened, why'd she wait 3 months to come forward? Why'd she wait until she met with the Ellis family attorney, Mr. Bible, and explain to me how in the world the 2 phones associated with this case, the day after they meet with Mr. Bible, mysteriously combust. Because I'm going to submit to you, if your phone breaks, you know how your phone broke. You know when it broke, how it broke, and then when you got the new phone. But that's not this case. Gee, I wonder why. Wonder what's on the phones that they didn't want us to see. How about communication between them and Mr. Bible? Hey, here's what we know has been reported. If you can alter or confront those facts, you might get some money. Who knows what their motivation is? Because they destroyed their phones. And they're not available for us to determine what that communication was. How else did they present their case in this case? Well, they paid a whole lot of experts, a whole lot of money to come in and tell you what they saw and what they heard and convince you don't trust your own eyes or ears. Right? They paid a whole lot of experts to come in and give opinions about cause of death, manner of death. But what they didn't do, they didn't provide those experts with the life pack before they made their opinions. Why in the world would you? Mr. Liu had it, right? Why didn't he give that to their experts? They didn't provide their experts any medical records as it related to Manuel Ellis before rendering their opinion. Why not? Well, because we know Manny had a history of heart problems, history of trouble breathing, multiple hospital visits to address those things, and that undermines their opinions. They didn't provide any of the treatment records as it related to Manuel Ellis. Why not? Right? Because we know in those treatment records what Manuel Ellis says. When I take methamphetamine, I get into a methamphetamine-induced psychosis. I have issues with police, and this is what happens. Because that didn't fit the story that the state is trying to sell you. What else do we know about the medical experts? Their opinions were based, and then you don't throw anything at me, on pulseless electrical activity. Right? You heard pulseless electrical activity 100 times in this, but their entire opinions were based on pulseless electrical activity and normal sinus rhythm until it wasn't, right? Because Mr. Liu didn't provide them with a life pack that showed that was not the case, and now that doesn't matter and doesn't change their opinions. That's what you get when you pay for an expert opinion. What else did the state not do? They didn't call a single witness that didn't support their theory of the case. There were officers all over the place who were present on scene. They didn't call a single one of them. Ask yourself why. Because it didn't fit their story. Right? You heard of an independent investigation team who did an investigation through the Washington State Patrol. Detective Rue, Detective Markin. Where are they? The state of Washington just put on a murder case without calling the investigating officers who investigated the case. Why not? Didn't fit their story. The state of Washington didn't call any civilian witness that didn't support their case. No, they called the three states' witnesses that had contact with Mr. Bible, and that's their case. During the course of the trial, the state chose to withhold evidence from you. Ask yourselves why. Didn't fit their theory of the case. Don't take my word for it. Recall the testimony. Ms. Nicolavo, through Steve Mell, introduced the scene photos. She introduced all the scene photos except which ones? The photos of the powdered sugar on the window and the donut box directly below it, showing that what Ms. McDowell said is not true. And so they chose not to introduce that because it didn't fit their story. What else? Asa Lewis. They didn't call Asa Lewis. Miss Eek stood up and told you Asa Lewis actually supports their theory of the case. That's crazy. We'll get to that in a minute. But they chose not to call the toxicologist who had sent the blood sample in, had the results, to interpret the results. It didn't fit their story. How about the injuries to Mr. Ellis? Recall Ms. Eakes introduced ad nauseum, road rash to the wrists, to the face, to the knees, every injury associated with Mr. Ellis, except one. I did it on cross. Remember I said, hey, on his left knuckle, that's actually a laceration. Laceration not consistent with what the state's theory of the case is. The laceration is consistent with blunt force trauma, punching a window. Why did they not introduce that? Didn't fit their story. The St. James Apartments. Remember, my client's on the stand testifying. Ms. Eek says, well, your Exhibit 77 doesn't contain, he threatened to whisper to kill us. So then on redirect, I get the entire packet with the whole use of force investigation. Officer Burbank's statements as well. All bait stamped from the Washington Attorney General's office, sequential in number. She chose to keep that from you because that was consistent with what Officer Collins said, which was useful in his assessment of reasonable use of force based on his experience. But we're not going to let you know that either because that doesn't fit their theory of the case. How about this? The hobble. Right? You were told this is 27, 29 inches. Go look at your notes. Right? Actually, it's not. Did a tape measure. It's actually 37 inches. 8 inches longer than they told you it was. Why is that significant? Why not just tell you it's 8 inches longer? Because they want you to believe that Mr. Ellis is in 4-point restraints such that he can't move. Well, 8 inches, you can move. You're no longer past 90 degrees, which doesn't inhibit the ability to breathe. We'll talk about that in a minute. So why didn't they tell you that? It didn't fit their story. How about this? In her closing arguments, Ms. Eakes stood up and told you, we know that Sarah McDowell saw the whole thing because the first mic click doesn't work. The first mic click is noted right here under dispatch, right? And Ms. McDowell's video says, hey, 1 second later, therefore she saw the whole thing. Except for that's not what that exhibit actually shows. In fact, read the paragraph introduction right above it. This is a transcript of video from 23:21:42 through 23:34:07. Well, what does that align to? That aligns to the Vivint video, same time, same stamp, and what do we know? They're fighting well in advance of the start of that video. Will become very clear once I get through this to mislead you about what Ms. McDowell saw. She then put up this in her PowerPoint slide with all the times that Mr. Ellis said, I can't breathe. We're going to get to I can't breathe in a minute. That actually has nothing to do with this case because it doesn't change what the officers were obligated to do. But that's what they have, and that's what they're going to pound the table with. And so she suggested to you that my client heard him say I can't breathe on all of these occasions, except for that's not true. Because remember, this exhibit was prepared by Dave Hallamore with his critical thinking and hearing skills and all of his amplification material to create this exhibit to go along with the audio and video that they played for you. Well, we certainly hear, as I've highlighted there on page 3 of 6, the Vivint video of Mr. Ellis saying, I can't breathe. We're going to talk about that more in a minute too, but that's the date and time stamp down there. Miss Eakes suggested to you on page 4 of 6 that right before officer says, shut the fuck up, man, that Mr. Ellis says, I can't breathe again. And that the shut the fuck up was responsive to Mr. Ellis saying, I can't breathe. Except for that's not what it says. That's not what their expert found, and that's not what the evidence is. In fact, if you believe it was responsive to I can't breathe, go back one page. 23, 28, that was, what, 14 seconds later? So somebody's saying shut the fuck up to something that happened 14 seconds earlier? Well, that doesn't make a whole lot of sense. And those aren't the facts. That's the story they want to sell you. She went on to say, And that you could hear it again at 20, well, don't take my word for it. Let's use Miss Eakes. 23, 25, 21 on her slide. That Mr. Ellis is saying, I can't breathe. Everybody heard it, apparently except for Mr. Hallamore using his critical hearing and enhancement devices.
Overruled. Continue.
That's what the testimony is. Those are the facts that have been proven during the course of this case. Ms. Eakes can object all she wants. That's what came from the stand. G, again, don't let the facts or the truth get in the way of the story. I'm about to speed this up. I'm not going to take 3 hours. It's going to take 3 hours to spin this because you know what happened. You saw what happened. But I want to take you back about 3.5 weeks ago when Miss Eakes stood up and said the state rests. See, we knew that was coming. You didn't know that was coming. I watched your reaction. I wish I had the ability to record it and put it on a slide. Because when Miss Eakes stood up and said the state rests, your jaws dropped. The physical reaction from you tells us everything you need to know. Because what you felt was shock. What you felt was disbelief because the state hadn't proved anything. That was a manifestation of reasonable doubt. Your physical reaction and looking directly at her with disbelief tells you the state didn't prove this case. And you know you did it. Those of you that did it know you did it. We saw you. Because that's what you felt, and that's what they proved. When you go back there, I want you to think about that when you're discussing, did the state prove this beyond a reasonable doubt? Because certainly what didn't happen is the state didn't prove the case after that point in time. In fact, it only got worse after that. And we'll talk about that. So let's talk about how to process this case. It's actually very simple. I know it was a long case, complicated case, but your job's actually pretty easy. The judge gives you a roadmap and gives you instructions. I'm going to submit to you first instruction, paragraph 1, and the last paragraph. Make it very clear. Your job is to determine what the facts were that were proven during the course of this trial. That's it. What was proven from the stand and through the exhibits that were admitted. Okay? And then apply the law that the judge gives you. And that's it. Decide the case based on those facts and circumstances. The judge then gives you what's called 2 convict instructions. The 2 convict instructions tell you the elements that the state has to prove beyond a reasonable doubt in order for you to find any of the defendants guilty, but I'm going to deal with my client, obviously, Officer Collins. The first paragraph of each of the 2 convict instructions, we're going to go through each of them real quick because I've outlined what's at issue. First off, the state has to prove each beyond a reasonable doubt. And Mr. Fricky had a slide about reasonable doubt. I'm going to submit it much simpler than that. We'll walk you through it. But in paragraph 1, or element 1, did Officer Collins commit assault? Doesn't matter which degree, both are felonies, 2nd or 3rd degree, or unlawful imprisonment. And 2, that the acts of my client caused the death. 2 separate and distinct things in dispute that the state has to prove and they failed to based on the facts presented. Well, instruction 12 tells you what an assault is. That's why I highlighted assault. Because an assault is an unlawful touching or striking, an intentional touching or striking with unlawful force. So if you're allowed to use the force, it's not an assault, therefore it's not felony murder. And you have to, in order to commit unlawful imprisonment, do so without legal authority. So if there was lawful force used, a basis to arrest, and a legal authority for unlawful imprisonment, we're done. Because the state has to prove that beyond a reasonable doubt. Well, how do we know that it was lawful to arrest Mr. Ellis? Well, instruction 28 tells you when it's lawful. The arrest is lawful if the arresting officer had probable cause, right? A reasonable officer thinks that there's a crime committed in their presence, that the person arrested committed the crime of assault or resisting arrest. Assault is punching a window, touching or harming Officer Collins, or resisting arrest during the course of the contact. So if there's probable cause to arrest Mr. Ellis, there is no predicate felony, and we're done. But those are the things that are at issue. We're going to talk about that. Then you have the manslaughter charges. Ms. Eakes only talked about reckless. That means she doesn't think there's negligence, but I'll go over that as well. Again, first paragraph, beyond a reasonable doubt, that my client or an accomplice engaged in reckless conduct. Now, Ms. Eakes kept saying they during the course of her argument. That's not the law. The only accomplices in this scenario, if you apply the instructions that the judge gave you, are Officer Collins or Burbank. They are not accomplices to any other officer, and no other officer is an accomplice to them. You must accept that as fact. It says it in the instruction. So did my client engage in reckless conduct? Well, reckless conduct in this circumstance is he knew of and disregarded a substantial risk of death. And we'll talk about that. There's no substantial risk of death in this conduct, but that's what's required. And that the acts of my client caused the death of Manuel Ellis. Again, we're going to get back to causation. But those are the disputed elements in these offenses. And Instruction 45 deals with the negligent prong, or the negligent, man 2 with the negligent as opposed to reckless. Again, have to prove that my client caused it and disregarded a risk of death, which doesn't exist. Excuse me. Mr. Fricke talked about reasonable doubt, and I'm going to suggest it's much simpler when you're applying these, because what the instruction says is a reasonable doubt is one for which a reason exists. Right? Is there a reason exists based on the evidence or lack of evidence that any of those elements are met? Right? Meaning, was it lawful? Did my client cause it? Was it reckless? Was it intentional felony? So the test is there a reason that exists based on the evidence that the state didn't prove this? What that means is if you can say to yourself, this fact is a reason to doubt one of those elements is met, then that's a reasonable doubt. Okay? It doesn't say 10 reasons. It has to be a single reason based on the facts that were presented and proved during the course of the trial. And so it's actually a pretty simple analysis, which we're going to get into in just a second. So, let's talk about right now the facts that were proven, that are kind of undisputed. And then the rest of it is kind of, you're going to have to decide what they actually mean as it relates to the charges in this case. So what's been proven? Well, I think it's clear that Mr. Ellis had a pre-existing mental health condition, that Mr. Ellis had a chronic meth problem, that Mr. Ellis's use of the methamphetamine exacerbated those things, that Mr. Ellis had a dilated heart as a result of his meth use, and we know how that impacted Mr. Ellis because we have a 2015 incident in which he's detained. Luckily, he was cuffed at the time he was in the car, in which 3 Pierce County Sheriff deputies had to remove him from the car, and once they did, he began to resist and kick and fight because he was high on meth. He had to be hobbled to prevent him from continuing to resist and fight because he's high on meth. I'm not saying this to disparage Mr. Ellis. These are facts that are proven, that are the context through which my client is acting on March 3rd. The state wants to say we're trying Mr. Ellis. We're not. But you can't ignore those facts because it goes into what's reasonable and what's happening on March 3rd. So we know that happens. We know that in 2019, he walks into, 6 months before this incident, by the way, He walks into an A&W and attempts to rob A&W. And the police are called, and Mr. Ellis resists and has to be tased twice. And it was caught on video. I'm going to play the video for you in a second. And what I want you to think about and listen to in the video, you can see Mr. Ellis crouching behind, and just so everybody knows, this is Exhibit 2513 when you go back. The reason we played this video, because it informs you about what's happening in 6 months later. Why do I say that? When I hit play, you're going to hear Mr. Ellis scream in the same exact manner he screams on March 20th when he's interacting with my client and other folks. And he's not being assaulted at all. He's high on meth, and that's how he's reacting.
This dude is butt naked. He was running down Pacific. Looks like he got tased. Yep, he got tased. Party's over. Only in Tacoma.
What happened after that? We know Mr. Ellis was charged with a felony in Pierce County. We know that the prosecutor's office agreed to release him on his personal recognizance so he could get treatment. We know that he had conditions of release not to use meth or commit crimes. And we know that was in place at the time of March 3rd. What else do we know? He actually went into treatment. And he actually was progressing pretty well in treatment. In fact, what you know from treatment are a couple of things. This is from some of the records that have been admitted. This is Exhibit 2019A. Brendan's talking about this, and Mr. Ellis says, I was in a psychosis for a day. I got naked because the voices told me. I was walking down Pacific Avenue, and the police stopped me, tased me. Now, over time, I assume that means every time, but over time, I see a police officer, I get anxiety. Why is that significant? Because that's exactly what happened on March 3rd, right? He's telling you, through his counselors, that when he's on meth, this is what happens. What else did he say? He told Miss Fonda, I think it's Fonda, and you have the records with regard to that, that when he takes methamphetamine, he gets in a methamphetamine-induced psychosis. And it exacerbates his mental health conditions. That's what Mr. Ellis says the effects of the meth are on him. And those are the facts that are proven, and that's the context in which this occurs on March 3rd. What else do we know? We'll get there in a second. We know that he was clean until mid-December, December 16th or 26th, depending on which record that you want to refer to. And that he then relapsed on March 3rd. So he went over 70 days, almost 2.5 months, without meth. That's going to be significant when we talk about Asa Lewis in a few minutes. But he abstains, and we know he relapses on March 3rd, and we know he has 2,400 nanograms in his system on March 3rd. And we know he took it probably a half hour before the incident, potentially bad meth. that exacerbated what exactly he told you happens when he takes meth and sees police. We know that his EBT card was used to buy the donuts and the water. Zeke says he walks down 96. I don't know. I didn't hear any evidence that he actually walked down 96. We don't know how he got there. Was he with Mendel? Were they smoking meth together? I don't know. But we know he ends up at 96 in Ainsworth. And then we know, based on the Vivint video, the first video that we hear at 23:21:38. Now, I'm going to play this and I'm going to walk you through what we actually see in this video because it's very significant about what actually happened. All right. So what do we know? We know as soon as that video comes on, the light's green, right? You can see the street light right there. So they're dealing with Mr. Ellis for some time before the video picks it up. The light's green and they're not moving. You can hear them struggling, and you can hear the noises that I just showed you from the 2019 coming from Mr. Ellis. You also hear the courtesy honk from Miss McDowell. Why is that significant? Because Miss McDowell didn't see what she told you she saw. Right? Light's green. She honks. And then what does she do? She backs up before she starts screaming, "Hey, what are you doing?" You can see it and watch it in the video. She's not even paying attention to what happened. She realizes the light's green. She honks, backs up, and sees them fighting, and then starts recording. That's what happens. We're going to tie that to both the CAD report from the previous stop and Miss Malang's testimony in a few minutes. But that's going to prove without a doubt that Miss McDowell didn't see what she told you she saw. It just does. That's Exhibit 546. Then you have the two videos from Miss McDowell. Now the state says the videos tell you the whole story. There's like 50 seconds of video that's in the middle of the fight. But the state wants you to believe that's what it is, because that's what they need you to believe in order to find they prove this case. It's just not. And those aren't the facts, and that's not the truth. So the first video is Exhibit 20. The first video shows Matthew Collins standing between Sarah McDowell, Officer Burbank, and Mr. Ellis. Why is that significant? Because she told you I saw the whole thing. And in fact, that was that was the passenger that was between us, and the driver was dealing with him, and then the passenger got on and started punching him. Remember? I cross-examined her about it and showed her the video. And she's like, well, maybe I don't know who it is. Right? She didn't see it. She catches it in the middle. She doesn't know which officer is which, and that was her explanation. But recall, Exhibit 20 shows Matthew Collins getting on top of his torso, and you see him deliver the elbows, right? The next video is 21. It's not even 10 seconds later, right? The first video shows about 13 seconds of actual footage. You can't see because she turns around and starts yelling at Keon, so she's clearly not watching what's happening. But explain to me, if it didn't happen just like Matthew Collins said, how in the world did Manny Ellis end up in the location you're about to see unless he came up through, just like Officer Collins said, I had to roll out of the way, and we both end up facing the intersection to the left. Because that's what he said. We're going to talk about that. I don't know, watch the video.
Behind your back. You can do it again. Put your hands behind your back. Hands behind your back. Put your hands behind.
Now what's significant about that? Well, you heard the courtesy honk again by Miss McDowell, so we know that was her. She did twice. My client's behind Mr. Ellis. Mr. Ellis is facing the intersection, and both officers are trying to restrain him. What are they not doing? They're not punching him. They're not hitting him. They have their hands on his hands as they're out in front saying, put your hands behind your back. Put your hands behind your back. Matthew Collins says it 4 times. No use of force. and they have to tase him to get the hands behind his back because he's resisting. That's Exhibit 21. Exhibit 19 and Exhibit 546 show you the corresponding video from Mr. Cowden. We're going to talk about Mr. Cowden in a second because the state tried to say they were all consistent and they were all credible. That's incredible, but we'll get there in a second. This is his perspective. Remember, I played this like 5 times with Grant Fredericks because he refused to accept that Mr. Ellis is actually resisting, in fact, actively resisting in this clip.
Energy 17, go ahead.
Hey, y'all in the wrong right now!
You got kids in the car, you dumbass, you already got Energy 17.
87. 9-6 major.
Alright, traffic energy 17 on trouble 968, we're 2622.
Try again. Go around them.
Energy 17 unreadable.
You see Miss McDowell and Mr. Lowry driving by, so that's overlaps.
Or your car back.
Overlaps entirely with what Miss McDowell's doing. Why is that significant? Well, the state wants you to believe, and Mr. Fredericks and Mr. Ryan took that 1/30th of a second still photograph and said, he's surrendering. That's not what actually is happening. What's happening? Burbank pulls out a taser, and he goes like this, and my client is pulling him down at the same time. He's not surrendering. In fact, what does he do immediately after that? He then starts grabbing at Officer Collins in the video, and then he's tased. And what does he do? He's grabbing for the wires to get the wires off. Grant Fredericks won't even acknowledge, even when confronted with Dave Hollamore's transcript that he reviewed and approved before he created this, in which Hollamore says, try again. Why does the state not want you to believe that? Because that's resistant. That shows exactly what Officer Collins is saying is happening. Try again. He tased him. He says, tase me again. Grant Fredericks, amazingly, in another opinion he provided you, suggested that Officer Burbank in that clip just fell off Mr. Ellis. Watch the clip. Mr. Ellis has the hand behind his back in a position you're supposed to have no strength. And he throws the officer off. He didn't slip off of him. He's got his knee between his legs. He's got him situated with the arm up in that position, and Mr. Ellis kicks out and throws him off. Active resistance, assaultive conduct. But Grant Fredericks can't admit that to you because that undermines their story. Don't believe your lying eyes, right? That's what they want to tell you. Believe our expert that we paid a ton of money to break it down in 1/30th of a second and tell you this is what's actually happened, despite what you can see happening. What else has been proven during the course of the trial? I don't know. The officers are stopped at the stop bar. If you want to believe Sarah McDowell that these guys attacked somebody walking down the street, why are they stopped at a stop bar? Just pull off like they're trained to do. They wouldn't stay at that location unless it happened exactly like the officer said it did. Facts proven during the course of the trial. I don't know, I see 4 separate strike marks there. Still haven't heard an explanation how it got there from the state. I think Ms. Nicolavo's redirect examination of Steve Mell was, well, you didn't test that, right? And what was his response? Well, if there were any question about what the substance was, I would have tested it. It was clearly powdered sugar. On the box that was torn apart, look at the photograph. Ms. Eek says it's closed. Yeah, the left part of it might be closed, but look at the right back of it. It's torn all open. And there's powdered sugar all over the ground where the box is. Go look at the exhibit. Those are the facts that are proven. Sorry, the truck, the patrol vehicle, Exhibit 166, Exhibit 2672. Pay attention. This is Exhibit 2731. And you can see the strike marks here, but you can also see a horizontal line accumulated of powdered sugar there. As if it's being punched and distributed and being rolled up and down. We know it was placed there at that location. Those are the facts that have been proven during the course of this. Injuries. Let's talk about injuries. Because the state suggests there's no evidence that that was put there by Mr. Ellis. Well, exhibit number 253. Mr. Ellis is left-handed. This is Mr. Ellis's left hand. What's on Mr. Ellis's hand? Looks like white substance to me. Right here, right here, right here. What's going on with his knuckles? I don't know. They're all swollen up as if you punched the window. Those are the facts that are proven. And by the way, the laceration that Miss Eakes just forgot to ask about on the left knuckle, consistent with blunt force trauma to the window. Those are the facts that are proven during the course of this trial. That's Exhibit 253. I'm going to buzz through this and wrap up in a second. What else do we know? Obviously, Mr. Ellis died. The cause of death, we'll talk about in a second, is clearly in dispute. So, back to your analysis. Are there reasons to doubt those elements based on the facts that were presented during the course of the trial? Of course there were. I'm going to list 20 of them. Go back in deliberation and say, do the facts support the existence of any one of these? And if the answer is yes, that's a reason to doubt the state proved any of these charges. How about this? How did it start? Right? I guess the state wants you to believe Sarah McDowell. We have the officer's version that's completely at odds with it. The physical evidence is consistent with the officer's version. There's a ton of other evidence that's consistent with it. But for argument's sake, one of two things happened. Either happened just like Officer Collins in Burbank said, or these officers just randomly attacked a guy walking down the street. If you believe that was proven, they're guilty. Okay? Except for the evidence doesn't support that. We're going to talk about why. McDowell, Lowry, and Cowden. I already talked about when they disclosed, why they disclosed the phones. I'm not going to belabor that. But what did each of those witnesses tell you that tells you they didn't see how it started and they're incorrect about that? All three of them said he had nothing in his hands. He had nothing in his hands as he walked down the sidewalk. I don't know, I remember Miss Eakes a while ago waving this around in front of you because she knows he bought that and that was in his hand. The box of donuts was in his hand. A bag was in his hand potentially. How did those three say they saw him walking down the sidewalk and yet he had nothing in his hands when we know he did? Because they didn't see it like that. That is a reason to doubt it happened as they said. And that's the facts that have been presented during the course of the trial. If that's true, then it's certainly not murder too. What else do we know? Well, we know that Cowden told you, I saw him walking down the sidewalk listening to his music, enjoying nature. Right? That's what he said. Some of you laughed when he said that because it's ridiculous. But what do we know based on the evidence? He could not have seen from that perspective where he said he saw this happening because it's obstructed by the trees and everything where the officer was located, the officer vehicle was located. In fact, go back and look at the exhibits. You have to be within about 5 feet of the stop line to even see the patrol vehicle from that location. What else do we know? Cowden says, I watched them drive into the intersection, following Mr. Ellis as he walked. Well, we know that didn't happen, right? The patrol vehicle still stopped at the stop bar. He didn't see it. He didn't see what started it. We know that Grant Fredericks reviewed the information from Mr. Liu about the traffic lights. What did he say on cross-examination? That Mr. Cowden arrived at the time the officers took Mr. Ellis to the ground based on the reflection of his headlights in the car, on the vehicle. So we know he didn't see what he said he saw. Yet the state stood up in closing and said they were all consistent. They all saw the same thing. Therefore, they can't, that's got to be true. What do we know about Sarah McDowell? Well, we know Sarah McDowell took great interest in this case once she got involved with Mr. Bible. In fact, this is an exhibit that's been admitted that shows, it's Exhibit 2652, correspondence between her and the spouse of one of the people that bailed my client out of custody, who she stalked on Facebook. She uses her Jesse Salgado, her now husband, Facebook account once she's blocked to harass her. Wait till I'm in the stands, I'm lying to shut you all down. What else did we know that was included in these? Blue lives is not a thing, black lives matter, blue lives don't. Her explanation, well, this is a typo. It's a typo. Well, we all have a keyboard. Go look at your keyboard. Because this wasn't voice to text, right? She's typing this. Where's an L and a D on a keyboard? They're at the opposite ends. Right? How do we know that's what she meant? Because it wasn't restricted just to this individual. I showed on cross-examination, she reached out to people in Wisconsin, in New York, in every news station that's addressed this. Right? And what'd she say? I saw the whole thing. He wasn't high. That's a lie. Well, we know that's not true. It didn't happen like that. They're making this up. She's confronting people, arguing with people on social media because it has meaning to her. Why does it have meaning to her? I don't know. I'd like to see her phone because I'd like to see what her conversation with James Bible was. But that's fact. Ms. Eek says you got to trust, right? No reason to doubt what she's saying happened. Those aren't the facts. How about this? This is exhibit number, well, I don't have it on with me. This is the, I think it's a 151J or something like that. This is the illustration done by Mr. Cowden about where Mr. Ellis was walking and the direction he was walking and the location of the police vehicle as it followed him. Well, that's the exact opposite that Lowry said. McDowell said both, quite frankly, right? I confronted her. She said it during my interview. He's walking that direction. And her testimony was he's walking the other way. He couldn't have seen what he said he saw. They're not credible. And if you don't believe them, the state didn't prove this. Because that's their entire case. That's why Ms. Eek spent the entire time talking about this and had pictures of those three witnesses throughout her closing.
It's now 4 o'clock.
That's probably a good idea, Judge.
Okay.
I'm not going to finish in the next 10 minutes.
Okay. All right, ladies and gentlemen, we'll be at recess till tomorrow morning. During this time, please do not discuss case among yourselves with anyone else, and do not permit anyone to discuss case with you in your presence, and of course avoid any reporting on the subject of this trial, wherever it may be.